afternoon, everyone, and hello to those dialing in. My name is Shane Murphy. I'm partner of DLA Piper. We're an international law firm with offices all over Australia, but certainly with a network in Africa. And just to speak to that briefly, as of Monday, we're the highest ranked international law firm in Africa. We have 100 partners and 450 lawyers in 20 African countries. We have a Perth office that specialises in energy and natural resources with an extensive track record in Africa and a market-leading international and investor state arbitration practice. And in that regard, that takes me to our special guest dialing in today from Paris. We have Michael Ostrove with us. Michael is from New York, a member of the New York and Paris bars. He has practiced for 25 years in international arbitration in Paris. He's the global co-chair of DLA Piper's arbitration practice. He's also Chambers Global ranked for his commercial and investment arbitration practice. And on the back of his representation of Guinea for the past 10 years in the investigation and investment arbitration over the Simandou deposit, as well as other matters around Africa, Michael's been ranked for 4 years by the leading African business magazine as one of the most influential lawyers in Francophone Africa. So Michael is today with us to speak to the investment disputes in the mining sector and to map out the recent trends in that space. So without further ado, I'd introduce Michael. Michael, are you there?
Can you hear me?
I can, yes. Good to have you on board, Michael. First of all, I think it would be useful, and we can see you now, so hello there. First of all, I think it would be helpful for us all to go back to basics, and it'd be great if you could give us a sense of what investor-state arbitration is and what investor law is, please.
Thanks. I could probably teach a university course for an entire semester on it, but I'll try and summarize it in 30 seconds. And let me also say it's been years that I've been hoping to be in Perth for Africa Down Under, and I'm sorry I'm not there in person this year, but it's great to be beamed in on the screen. When we talk about investment arbitration, we can talk about a lot of things, but what we're really focusing on is an extra set of protections for investors beyond what they can negotiate in their contracts and beyond their ability to bring in international arbitration to protect their investments. We're talking about international law, usually in the form of international treaties, that requires states to promote and protect foreign investment. And sometimes these international law protections are actually built into local law in the form of investment codes. And otherwise can be put into international agreements and investment agreements. And so what we try to look at is when you're making an investment anywhere in the world, but today's focus is on Africa, making sure that you're aware of these investment protections. Sometimes investments have to be structured to take advantage of them because Australia has only one investment treaty with an African country which provides these international protections, but there are thousands of these treaties out there, and when investment is channeled through, for example, Mauritius or the UK or the Netherlands, often you can structure not only to have tax benefits, but to take advantage of international investment law protections.
Thank you. Well, I think we'll dive straight into the first topic, and that's around recent trends in investment disputes. What are the key trends that you think stakeholders in the mining sector should be aware of in the African investment law landscape?
There's been really a sea change in investment law globally, and Africa's at the forefront of that in a lot of ways. For the first 20 or so odd years of claims under investment law, it was all about investors who had either been expropriated or felt they were unfairly treated, going after states as a matter of international law and seeking reparations. And more today, we're seeing states insist that investors also have obligations to respect local law, to carry out environmental and social impact statements, and in general to be more transparent about their investments. So really probably the biggest trend is both some treaties actually incorporating obligations more specifically on investors, and states just getting much more wise to the fact that when an investor comes in and raises an investment protection claim, the state often has defenses if that investment was not made way back at the origin in compliance with local law.
Okay. And in relation to transparency, I'd noticed recent news that as a prerequisite to signing with a 3-year plan with the IMF, the DRC recently published all of its mining contracts. Is that part of a trend, and was that a surprise to see?
That wasn't a surprise at all, because the World Bank has been working with the DRC for years since HIPC to make sure that it's being more transparent about all of its debt, and now that's moved on to the mining contract world. So that's not a surprise, and there's definitely a global trend, especially with the Extractive Industries Transparency Initiative, to make sure that all mining concessions and conventions are public. In Guinea, where I work a lot, the government has been publishing all mining conventions for quite some time. But it has a very important impact that people have to be aware of, because sometimes relationships with the state are very smooth and easy and go very quickly, and investments are put into place. Sometimes not necessarily intentionally, but cutting corners a little bit on something. With the increase in global transparency, there's a really big non-governmental, not-for-profit civil society move to study these conventions, to look at the circumstances. And very often what we find is governments put under pressure to review all of their mining conventions, to do legal reviews, or to investigate specific conventions, because it's civil society on the back of transparency initiatives and saying something doesn't look right here. Does this really comply with local law? Is this the kind of investment that we want? So it's something that plays directly into this concept of investment law and whether investments can be protected or not.
Thank you. And one thing, certainly my clients and many clients with mining projects in Africa and elsewhere are very sensitive to around costs, and I know that these investment cases can be very expensive. Can you speak to that and what funding options are available in relation to investment cases?
Sure. It's an issue that always gets a lot of attention, and particularly in today's global economy, the cost of these kind of cases is very important. It sometimes surprises people when they see the price ticket that comes along with an investment arbitration. These are not the same as going down to court and bringing a contract claim. They involve expenses of international institutions, paying leading arbitrators around the world to take on the cases, and the average cost of bringing one of these cases is can easily be in the $1.5 million to $2 million range. So today, more than ever, people are looking at this and saying, well, I'm a relatively small company. I have lost one of my key projects in X, Y, or Z country. How do I finance this? If I have to go out to the market and take a loan out to bring this case, I don't have necessarily the security package, or I'm going to be paying very much above market interest rates. Over the last decade, we've seen a huge growth in third-party funding of litigation generally, and more specifically of investment claims and arbitration. And there are, frankly, billions of dollars in the market in hedge funds that specialize in funding investment claims. And they do that on a non-recourse basis. So they'll pay all the costs of bringing a claim, and if the claim loses, there's nothing off the balance sheet of the company, because there's no recourse. It's not a loan, it's funding. And then if they win, they share in the upside of the proceeds. So that's facilitated the bringing a lot of claims. On the flip side, there's been a big backlash and an attempt to have more transparency now in the third-party funding market, not just in the extractive industries, and obligations on parties to reveal who's funding their claims. So even the ICC, the International Chamber of Commerce, just changed its arbitration rules, and effective January 1st, anyone who brings an ICC arbitration with third-party funding will have to disclose the source of the funding to make sure there's no hidden conflicts of interest in the background that need to be taken into account.
Thank you. So changing tack, perhaps we could speak a little bit about flashpoints where these sorts of claims typically arise. And first of all, I was interested to hear from you on how and when disputes regarding mining projects typically arise in the Africa context, but more broadly as well.
It will obviously be hard to generalize too much. There have been dozens and dozens of claims around the world with respect to mining projects. But what we've seen over the last few years, I could just give you some examples from personal experience. More and more, as I mentioned, countries are under pressure to review mining conventions and mining licenses that have been granted in their countries. So, for example, in Guinea, I was involved in the technical committee review that was set up by Guinea, funded in part by the African Development Bank, to review all mining licenses and titles that have been granted there. And it was in the course of that review that investigations were undertaken, saying, why, how did this right or that right get granted? Are we sure all the proper steps were taken? Were feasibility studies properly prepared, et cetera? And in that context, there were obviously issues that came out about how a small diamond mining company had taken off half of the two most important iron ore blocks in the world off of Rio Tinto and obtained those rights. And in the course of that review, evidence came out that what later turned out to be $30 million had been paid through fake invoicing and other means to the former to the wife, the fourth wife of the former president of Guinea.
Did you say?
So that, sorry?
Did you say fourth wife?
Fourth wife, yes. The first three are all alive and well, but his young fourth wife was the most influential, as the president there was getting very elderly, and she became the key lobbyist for BSGR in that case. So that was an example of a mining review leading to an investigation, which led to evidence of corruption, which led to a withdrawal of mining rights over what everyone knows is one of the most important iron ore deposits in the world, which then led to a claim of expropriation by BSGR and years of litigation. Fascinating stuff. If anyone wants to watch 10 days of arbitration hearings, it's all available on YouTube. If you're having trouble falling asleep at night, I highly recommend it. But that's one example. Another example, similar review of issues in Kenya. Our firm represented Kenya in the Cortec versus Kenya case, where, again, it turned out that from the mining company's perspective, everything had been going well. They weren't paying too much attention to, as they called it, technicalities, but environmental and social impact assessments had not been performed. And the tribunal in that case determined that an investment that's made without following the legislative requirements for environmental and social impact assessments is not an investment that's been made in accordance with local law and is not subject to any international law protections. And therefore, there was no protection for Cortec, and it lost its case. So that's really been, I think, one of the key flashpoints is when reviews show that someone has cut corners or even in some cases just not documented things well enough, it can lead to very complicated situations.
Thank you. And what sources of rights can investors rely on in this context?
So the best source for any investor is going to be the rights that it's negotiated for itself. So when you're going in and you've got a mining convention or concession, make sure that those rights and obligations have been very clearly laid out and negotiated. When things go off the rails, then one of the key sources in a lot of African states, as I mentioned before, is investment codes, because often these codes were drafted with World Bank support and provide protections against expropriation and unfair treatment. And as I mentioned also earlier, if you structure through a third country where you pick up investment treaty rights along with perhaps taxation rights, those will give direct rights. So as an example, though it wasn't really structured for this, we recently handled a case for an investor against Madagascar. It wasn't in the mining sector, but it just as well could have been. There it was a factory that was destroyed in rioting, and the investor tried locally to get paid under his insurance policy, but it was a state-owned company, and the state ran interference, went to local court, won, lost, years and years and years lost locally. But then he realized he could bring claims under the Netherlands, the Belgian, Luxembourg, Netherlands investment treaty with Madagascar, and obtained full reparation for the loss of his factory on the grounds that the state had failed in its international obligation of full protection and security of the investment, because the national police just didn't show up. And when they showed up, they just sat and watched as rioters looted a factory.
Gosh. Thank you. We only have a little bit of time left, and I thought it might be good to hear from you on advice you would give to investors and states to mitigate the likelihood of a dispute. What can you say to that?
I think the clearest thing today is as the world is shifting to more environmental and social obligations and local content obligations, and sometimes those obligations aren't necessarily clear under local law, is really on both sides, on the state side and on the investor side, making sure that the decrees have been issued, the arrêtés have been issued, the laws have been clarified to make sure that everyone's clear what the obligations are, and then making sure they've taken the time to paper not just a broad statement of what will be done, but really clear statements and guidelines of how things can be done so there's not ambiguity. And that would be key issue number one. And the second issue is there are often consultants that are used to help people navigate legal, cultural, and other issues on the ground. It is absolutely imperative to make sure that the contracts for those are clear, that the relationships are disclosed, that everyone knows who's playing what role, because we've seen it over and over again that comes back to bite people afterwards. Everything going on with Rio Tinto years later, having its settlement with the government of Guinea put into question because it came out that they had paid consulting fees to a close friend of the president. I think everyone's seen in the press what that's led to in years of litigation and years of difficulty. So making sure that on both sides, everyone's transparent about how discussions are happening and have made their contracts clear can go a long way to avoiding having problems arise later.
Thank you. I think that's probably our time.